Hey everyone, and welcome back to the Deep Dive.
Great to be here.
Today we're diving into something, well, pretty crucial, but also, let's face it, sometimes a bit tricky.
Uh-huh.
It's those rules that decide which country's law applies when a legal problem, like a tort, crosses international borders.
Right. The choice of law rules for torts. Things like negligence, accidents, maybe even defamation when there's an international element involved.
Exactly. Like if someone from England crashes in France, but the driver's German, whose rules do you use?
Yeah, it's a fundamental question. Whose rules on, say, damages or negligence, or even can you sue your spouse? It's not obvious.
Not at all. So we're going to unpack this using some really helpful source material.
And we should definitely give a shout out to the University of London for making these documents available. This is all for educational purposes, of course.
Absolutely. And this deep dive is brought to you by Sinorbit Academy in Sri Lanka.
And for all of you listening, especially if you're studying for an exam on this, we really hope this helps. Good luck.
Yes, seriously, the very best of luck. Our aim today is to walk you through this, pull out the key stuff, and help you feel ready.
So the plan is to trace how English law has tackled this over time. We'll start with the old common law position.
How the courts first figured it out.
Exactly. Then we'll look at the big reforms in the 1995 Act.
The Private International Law Act.
That's the one. And finally, we'll get to the current system, which is mostly under the Rome II regulation.
Okay, so the mission is grab the key rules, understand the concepts, and look at examples to see how it all works.
And we'll definitely be repeating those important concepts, the case names, the key facts.
I really hope it stick for the exam.
Precisely. Shall we jump in with the historical common law rules?
Let's do it. So, before specific laws were passed for this, how did English courts decide if a tort happened abroad or partly abroad?
Yeah, our sources say it was, well, a real challenge, caused a lot of debate, a lot of trouble for a long time. It wasn't straightforward.
I can imagine. What were the options they considered?
Well, there are a few ideas floating around. One, maybe the simplest for the court itself, was the lex fori.
Lex fori, law of the forum, meaning just use English law if the case is heard in England.
Exactly. The court applies its own law. Easy for the judge.
But maybe not very fair if everything actually happened somewhere else.
That's the criticism, yes. Convenience over connection. So another idea, probably more intuitive, was the lex loci delicti commisi.
Okay, Latin. What's that one mean?
It means the law of the place where the wrong was committed. You'll hear lex loci delicti a lot.
So where the accident happened or where the trespass occurred?
Mm-hmm.
That sounds logical. The law of the place.
It does, and it's a very common approach globally, but, even that had its problems.
Well, like what?
Like, where exactly was the wrong committed? What if the negligent act happens in country A, but the injury happens in country B?
Right. The faulty product example. Made in A, sold in B, injures someone in C. Which one is the lex loci delicti? Where it was made badly or where the harm occurred?
Precisely. That distinction caused real difficulty under a strict place of the wrong approach. It showed the limits of just picking one spot on a map.
So people started thinking differently, more flexibly.
Yes, legal thinkers and some judges started pushing for something called the proper law of the tort.
The proper law, meaning the most appropriate law.
Kind of. Morris, a key writer mentioned in our sources, suggested it was the law with the cis. Wait for it. Most significant connection to the whole situation, based on policy.
Most significant connection. That phrase sounds important, like it's going to come up again.
It definitely does. It marks a shift towards looking at all the links, not just one location. It's more qualitative.
And this idea caught on.
Very much so, especially in the U.S. around the 1960s. There was a big case, Babcock v. Jackson. Remember that name, Babcock v. Jackson.
Okay, Babcock v. Jackson. What did it say?
Well, Justice Fuld in that case said something quite insightful. He talked about achieving justice and fairness by giving effect to the law of the place that has the greatest concern with the specific issue.
The greatest concern. So not just where it happened, but which place has the strongest policy interest in that particular legal question.
Exactly. It's policy-driven, flexible. And this U.S. approach, this focus on greatest concern or significant connection, definitely influenced English law as judges looked for more flexibility, too. Cases like Boys v. Chaplin and the Red Sea insurance case reflect that.
Okay, so that flexible thinking was bubbling under. But what was the actual dominant rule in England before the 1995 Act kicked in? This is the one we really need to know, right?
Absolutely. This is fundamental. The rule was the double actionability rule. Let's say that again. The double actionability rule.
Double actionability. And it came from which case?
It was laid down clearly by Justice Wills and Phillips v. Eyre. That's 1870. Repeat that name. Phillips v. Eyre, foundational case.
The Phillips v. Eyre. Got it. So what did this double actionability rule actually require? What were the conditions?
Justice Wills set out two conditions. You needed both for a successful suit in England based on a tort committed abroad.
Okay, condition one.
Condition one. The wrong must be of such a character that it would have been actionable if committed in England. This is the lex forbit. Basically, English law had to recognize it as a valid claim. It had to be actionable here.
Makes sense. What's condition two?
Condition two. The act must not have been justifiable by the law of the place where it was done. That's the lex loci delicti requirement.
Not justifiable. What exactly does that mean? Does it mean it had to be a tort in the foreign country too?
Not necessarily identical. It meant it couldn't be perfectly legal or excused there. It had to be wrongful in some way, capable of attracting some kind of civil liability or penalty under the foreign law. Just not okay there.
So, under Phillips v. Eyre, you needed two things. Actionable in England and not justifiable where it happened. Like needing two keys to unlock the claim.
That's a good way to put it. That was the general rule. But, as we said, courts felt it could be too rigid. This led to a really important House of Lords case. Boys v. Chaplin in 1971. Repeat. Boys v. Chaplin. This was the big chance to rethink Phillips v. Eyre.
And did they ditch the double actionability rule in Boys v. Chaplin?
Not entirely. The majority actually confirmed that the double actionability rule from Phillips v. Eyre was still the general rule. But, and this is crucial, Lords Hodgson and Wilberforce carved out a major exception, an exception that became authoritative. Repeat. Boys v. Chaplin introduced an authoritative exception.
An exception to double actionability. How did it work?
The exception said that even if double actionability was the general rule, a specific issue within the case could be governed by the law of the country which, for that issue, had the most significant relationship with the events and the parties. Repeat that test. The law with the most significant relationship.
There it is again. Most significant relationship.
So this exception brings that flexible idea right into the common law rule. You could look at, say, just the question of damages.
Exactly. Instead of applying the double actionability rule rigidly to everything, the court could isolate an issue like calculating damages, or whether a duty exists and ask, which country's law is most closely connected to this specific question? That sounds much more flexible. How did it work in Boys v. Chaplin itself? Remind us of the facts and outcome.
Sure. Boys v. Chaplin. Two British servicemen stationed in Malta. Car accident in Malta. So Malta was the lex loci delicti, the place of the wrong.
Okay.
Under Maltese law at the time, you couldn't get damages for pain and suffering.
So under the strict double actionability rule, the second limb not justifiable, where done might fail for that aspect of damages, because Maltese law effectively justified not paying for pain and suffering.
Precisely. It looked like the claim for pain and suffering would fail. But using the new exception, the House of Lords said, look, for the issue of damages, both parties are British, connected to England. England has the most significant relationship to that issue. Repeat. England had the most significant relationship regarding damages.
So they applied English law to the damages question?
Yes. They displaced the Maltese law on damages, the lex loci delicti, and applied English law, which did allow recovery for pain and suffering. So the plaintiff got those damages. Repeat. Boys v. Chaplin used the most significant relationship exception to displace the law of the accident location, Malta, and apply English law to damages.
That clearly shows the exception allowing English law in.
Right.
But you said it wasn't just a one-way street.
Correct. The exception was about finding the genuinely most connected law. And in a later case, Red Sea Insurance Co. Ltd v. Booges S.A., remember the Red Sea case? The principle was confirmed that the exception could also work the other way.
How so?
It could be used to disapply the first limb of the double actionability rule, the English law, lex fori requirement, and apply only the law of the place where the tort happened, lex loci delicti, if that place had the most significant relationship to the issue.
So the exception wasn't just a tool to favor English law. It could point either way, depending on the connections.
Exactly. Genuine flexibility. And this was approved again later in Pierce v. Ova-Arup partnership.
Okay, let's sum up the common law position before the big statutory change. The general rule was the double actionability rule from Phillips v. Eyre. Actionable in England, A and D, not justifiable, we're done. Repeat. Double actionability from Phillips v. Eyre.
But, subject to the crucial exception from Boys v. Chaplin, this allowed a specific issue to be governed by the law with the most significant relationship to that issue, potentially displacing one or both limbs of the double actionability rule. Repeat. exception based on most significant relationship from Boys v. Chaplin.
Phew. Okay, that's the history. And why do we still need to know this old common law stuff today?
Because it's not entirely history. The key reason is that these common law rules, especially regarding defamation, still apply to certain torts that were left out of the later reforms, specifically defamation and invasion of privacy.
Oh, right. So for defamation and privacy claims today, you still have to think about double actionability and the Boys v. Chaplin exception.
Essentially, yes, particularly for defamation. The principles derived from that common law framework remain relevant because of how the later statutes were drafted. So you absolutely need to understand it.
Okay, really important point for anyone studying this. Don't ignore the common law, which takes us to the next stage, the statutory reform.
Yes, the Private International Law Miscellaneous Provisions Act 1995 Part 3 came into force in 1996. Big changes.
What did you do?
It basically abolished the common law choice of law rules for most torts, not all, but most, and it replaced them with new statutory rules.
Aiming for more clarity again.
That was the goal, provide statutory certainty. But remember the scope issue.
It didn't cover everything. You mentioned defamation and privacy again.
Exactly. The 1995 Act rules apply unless the tort is now covered by the later Rome Statute legislation or if it's specifically excluded. And the big exclusions that mean the 1995 Act framework and related common law for defamation still applies are defamation and invasion of privacy. Repeat, defamation and privacy generally fall under the 1995 Act regime, not Rome II.
So the 1995 Act is like a bridge, and it's still the main road for defamation and privacy claims.
That's a good way to think about it. Now, for the torts it does cover, what's the main rule under the 1995 Act? It's in Section 11.
Okay, Section 11, what's the test?
The applicable law is the law of the country where the events constituting the tort or delict occur. Repeat, where the events constituting the tort occur.
That sounds different from common law. Focuses on the events. What if the events are spread out?
Good question. The Act tries to address that. Section 11.2 has specific rules. Our source highlights the one for personal injury claims.
What's that rule?
For personal injury, the applicable law is the law of the country where the individual sustained the injury. Section 11.2a, repeat. Personal injury law is where the injury was sustained. Clear location focus for that type of harm.
Okay, so general rule is events, but for personal injury, it's specifically place of injury. Seems clear.
It was meant to be. But like the common law, the 1995 Act also included a way to be flexible, a way out of the main rule if needed.
An exception.
Yes. They call it the displacement rule. It's in Section 12. Repeat, the displacement rule. It's a flexible exception.
And how does this displacement work under the 1995 Act? What's the test this time?
Section 12 says the general rule in Section 11 can be displaced if it is substantially more appropriate for the law of some other country to apply. If so, that other country's law applies instead. Repeat the test. Substantially more appropriate.
Substantially more appropriate. Okay, so common law had most significant relationship. The 1995 Act is substantially more appropriate. Are they basically the same?
There's some debate. Some argue substantially more appropriate might be a slightly higher hurdle, needing a stronger reason to displace the main rule. But the basic idea is similar. Allow flexibility if the main rule gives an inappropriate result because the connections point strongly elsewhere. The source mentions Edmonds v. Simmons as a case applying this. Remember that name? Edmonds v. Simmons.
Just hammering this home. Defamation.
Still carved out. Section 13 of the 1995 Act explicitly says that for defamation claims, the common law rules double actionability with the Boys v. Chaplin exception continue.
Right. Defamation gets special treatment throughout.
It does, reflects its specific challenges.
So, summing up the 1995 Act, statutory rules replacing common law for most torts. General Rule S11 is where events occur, or injury sustained for personal injury. Displacement rule made 12 if another law is substantially more appropriate. Still applies to defamation and privacy, preserving common law rules for defamation. Got it.
That captures the key elements of the 1995 Act, which leads us smoothly into the modern system.
Dominated by
Rome II regulation.
Rome II EU law originally.
Yes, an EU regulation on the law applicable to non-contractual obligations. Came into force across most EU states from January 11, 2009. Covers torts, but also unjust enrichment, other things.
And for us in the UK now, post-Brexit.
Still applies. The UK kept the Rome II rules in domestic law after Brexit. So for torts happening after it came into effect, Rome II seconds is generally your starting point in a UK court.
Okay, so Rome II is the current main player. But does it apply to everything, like torts that happened way back?
No. Crucial point, Rome IIX is not retrospective. Say it again, not retrospective. It only applies to events giving rise to damage that occurred on or after July 11th, 2007.
July 11, 2007, that's the key date.
It is. Anything before that, you use the old rules common law or the 1995 Act, depending. You absolutely must check the date.
Got it. Check the date first.
Yeah.
Now, does Rome II, it cover all torts from that date onwards?
No, it also has important exclusions, mainly in Article 1, things like family law matters, wills, company law, and guess what?
Let me guess. Defamation and privacy.
You got it. Article 1 explicitly excludes violations of privacy and rights relating to personality, including defamation. Repeat, defamation and privacy are excluded from Rome II.
So they still fall back to the 1995 Act and the common law rules. That consistency is helpful, actually.
It is. It keeps those specific torts under the established domestic regime. So Rome's stagger for most torts post-2007, but not defamation or privacy.
Okay. What else is important about Rome II scope?
It's universal application. Article 3. Repeat. Universal application. Meaning the law chosen by Rome II applies whether or not it's the law of an EU country.
Wow. So an English court applying Rome II could end up applying, say, Brazilian law or Japanese law, even if the case has no other link to Brazil or Japan.
Exactly. If Rome II's rules point to Brazilian law, the English court applies Brazilian domestic law. The only trigger is the case being heard in a country applying Rome II, like the UK. It's designed for consistency across borders.
Universal application. Powerful stuff. What about Remboy? That complex idea where one country's rules point back to another's.
Rome II shuts that down completely. Article 24 is very clear. Remboy has no place. Repeat. Remboy has no place. When Rome II points to the law of country X, it means the internal domestic law of country X, not its choice of law rules. Keeps things simpler.
Good. No Remboy rabbit holes. So let's get to the main rules in Rome II for general torts.
Okay, the general rule is in Article 4. It's got 3 parts: a main principle, a specific exception, and a general escape clause.
A 3-step process.
Sort of. You work through them.
Yeah.
The source notes, it's structurally a bit like the 1995 Acts approach, but the actual tests are different.
And this Article 4 applies to standard torts.
Yeah.
Like negligence.
Yes. A non-contractual obligation arising out of a tort delict, unless it's one of the torts with its own specific rule later in Rome II, Articles 5 to 9.
Like what? Which torts have their own rules?
Things like product liability will look at that unfair competition, environmental damage, IP infringement, industrial action. So always check first. Is it excluded entirely? Like defamation. Does it have its own specific rule, like product liability, or does it fall under the general Article 4?
Okay. Assuming it falls under Article 4, what's the main principle? Article 4.
Article 4.1 states, unless otherwise provided, the law applicable shall be the law of the country in which the damage occurs. Repeat. Law of the country where the damage occurs.
Place of damage. That's the default. Different again from common law's double actionability or the 1995 Act's place of events.
Yes. Rome II focuses on the result, the damage. And it says this applies regardless of where the act causing the damage happened or where indirect consequences are felt. It's about the direct damage location.
But surely where the damage occurs can be tricky sometimes too. What about that rotting goods example?
Exactly. The source raises that. Goods rotting on a lorry crossing Europe. Where does the damage occur? When the cooling failed, when the rot started, when it was discovered.
Tricky. What's the likely answer?
The source suggests sometimes the only practical answer is the law of the place where the damage was discovered, but it's not always obvious.
And even harder for purely financial loss, like negligent advice causing someone to lose money. Where does that damage occur?
Big problem. Is it where the bad advice was received? Where the losing investment was made? Where the bank account is? Pinpointing economic damage location is tough. The source suggests that for these hard cases, you might need to use the escape clause in Article 4.3.
Okay, so 4.1. Place of damage is the starting point, but maybe not the end point. What's the first way you might depart from it?
Through the specific exception in Article 4.2, this is really important. It covers cases where the parties are connected.
How does it work?
Article 4.2 says if the person claimed liable and the person who suffered damage both have their habitual residence in the same country at the time the damage occurs, then the law of that country applies. Repeat, common habitual residence at the time of damage.
Wow. Okay, so if the claimant and defendant both normally live in, say, Italy, then Italian law applies even if the accident happened in Spain.
Precisely. It displaces the 4.1 place of damage rule. The idea is their shared home law should govern their relationship, including torts between them, regardless of where they happen to be. Note the timing. It's habitual residence at the time the damage occurs.
That's a massive exception. Common habitual residence under 4.2 overrides place of damage under 4.1.
Correct. Now, what if 4.1 point somewhere N42 doesn't apply because there's no common habitual residence. Is there another way out?
The escape clause.
Yes, the general escape clause in Article 4.3. This is for more unusual situations. It says the law of another country applies if it's clear from all the circumstances that the tort is manifestly more closely connected with that other country. Repeat the test. Manifestly more closely connected.
Manifestly. That sounds like a really high bar, higher than most significant relationship or substantially more appropriate.
Generally, yes. Manifestly suggests the connection must be obvious, really clear, undeniable. It's meant for exceptional cases where applying 4.1 or even 4.2 just feels wrong because the links elsewhere are so strong.
What might count as manifestly more closely connected?
The source gives an example, maybe a pre-existing relationship like a contract. If the tort is very closely linked to a contract governed by, say, English law, even if the tort technically happens abroad, a court might find the tort itself is manifestly more closely connected to English law under 4.3.
And can this 4.3 escape clause override both 4.1 and 4.2?
Yes, the wording allows it to displace the law indicated by either paragraph 1 or 2. But realistically, it's probably more likely to displace the 4.1 place of damage rule. Why? Because if 4.2 applies common habitual residence, that's already a very strong connection, making it harder to argue another country is manifestly more closely connected.
Okay, so the Article 4 process is 1. Check 4.1, place of damage. 2. Check 4.2, common habitual residence. If yes, apply that law. If no, stick with 4.1 for now. 3. Check 4.3, is it manifestly more closely connected elsewhere? If yes, apply that law. If no, stick with the result from step 1 or 2.
That's the logical flow. And remember, this is only if the tort isn't excluded or doesn't have its own specific rule, like product liability in Article 5.
Right. Tell us quickly about Article 5 for products.
Okay, Article 5 deals with damage caused by a product. First thing, it's still subject to Article 4.2. So if the maker, seller, and the victim share a common habitual residence, that law applies first, even for product liability.
Common HR always wins if it applies.
Got it.
What if no common HR?
Then you go to Article 5.1, which has a special cascading series of rules. You check them in order, repeat, cascading series for product liability.
Cascade. Okay, step 1.
Article 5.1a. Law of the country where the victim had their habitual residence when the damage occurred, but only if the product was marketed in that country. Repeat. Victim's HR law, if marketed there.
A marketing condition is key.
Very key. Protects producers. They generally face the law where they chose to sell. So if it was marketed in the victim's home country, that law applies, even if they bought it or got hurt elsewhere.
What if not marketed in the victim's home country? Next step.
Step 2, Article 5.1b. If A fails, then it's the law of the country where the product was acquired, again, only if it was marketed in that country. Repeat, place of acquisition law, if marketed there.
And if not marketed there either. Third step.
Step 3, Article 5.1c. If B fails, it's the law of the country where the damage occurred, again, only if it was marketed in that country.
Yep.
Repeat, place of damage law if marketed there.
So the product liability cascade is victim's HR place acquired on place of damage, but each step depends on the product being marketed there.
Exactly. If none of those apply, maybe not marketed anywhere relevant, you might fall back to Article 4.1, or use the special product liability escape clause in Article 5.2, which also uses a manifestly closer connection test.
Okay, that's a complex one. And Rome 2 also covers things like unjust enrichment.
Yes, the source mentions unjust enrichment is covered by Rome 2.2, but dealt with in the next chapter of their material.
Right, wow. Okay, that's a lot of rules. Let's try to quickly recap the journey again.
Good idea. We started way back with common law. The double actionability rule from Phillips v. Eyre, needing actionability in England, and the non-justifiability abroad.
But softened by the Boys v. Chaplin exception, allowing the law with the most significant relationship to an issue to apply instead.
Then the 1995 Act came in, statutory rules, general rule, place of events or injury sustained, with a displacement rule if another law is substantially more appropriate.
And crucially, the 1995 Act regime still applies to defamation and privacy.
Then Rome 2 developed for events post-July 2007, not retrospective, universal application, no renvoi.
For general torts under Rome 2, Article 4, General Rule 4.1 is place of damage.
Displaced by exception if parties share common habitual residence at the time of damage.
Or displaced by the escape clause, 4.3, if manifestly more closely connected elsewhere.
And remember, Rome 2 has specific rules, like the product liability cascade, and it also excludes defamation and privacy.
Okay, thinking about those learning outcomes from the source, can you outline the rules for each era? Can you explain the different displacement tests? Can you explain the special status of defamation and privacy?
If you can tick those boxes, you're doing well.
Definitely. Now let's make this concrete. Let's work through those examples.
Perfect. Applying the rules is key.
Example 1. Self-assessment. Question 1. A. English resident, passenger in France. Injured. Car hired by English friend from X & Co. English company, Calais branch. Injury due to X & Co.'s negligent maintenance in France. Sues X & Co. in England. What law governs the standard of care?
Okay, breakdown. Tort is negligence. Assume the injury happened post-July 2007.
Let's assume yes, so Rome 2 applies.
Right. Negligence is a general tort, so Article 4, start with 4.1. Where did the damage occur?
The injury happened in France, so 4.1 points to French law.
Okay, now check 4.2. Common habitual residence. A is English resident. X & Co. is an English company, but acting through its French branch where the failure occurred. Are they habitually resident in the same country for this purpose? Probably not. Unlikely 4.2 applies.
Right, so back to 4.1 unless 4.3 applies. The escape clause, is it manifestly more closely connected elsewhere, like England?
Well, A is English, X & Co. is English, but the bad maintenance was in France, hire from French branch, accident in France, injury in France. The core events are French. Is the English connection manifestly stronger? It's a high bar? Seems unlikely.
So the probable outcome is French law applies under Article 4.1, determining the standard of care, just like Activity 8.2 suggested for a similar German scenario.
Exactly. Let's try the next one. Question 2. Defamation. X & Co., English company, publishes magazine in New York. Libels A NY politician. Actionable in England, but not in NY, public official rule. Sues X & Co. in England, would claim succeed.
Okay, tort is defamation. Libel, which regime?
Defamation is excluded from Rome 2, so we use the old rules. 1995 Act preservation of common law rules, meaning double actionability from Phillips v. Eyre, plus the Boys v. Chaplin exception.
Right, apply double actionability, condition 1, actionable if committed in England. A source says yes, condition 1 met.
Condition 2. Was the act not justifiable? We're on New York. Source says it's not actionable in NY, so it is justifiable there. Condition 2 is not met.
So under the general double actionability rule, the claim fails because it was justifiable in New York.
Correct. But
Yeah.
the Boys v. Chaplin exception, could the law with the most significant relationship apply?
Which law has the most significant relationship to the issue of actionability? England, defendant's home, forum. Or New York, place of publication, plaintiff's home, main reputation damage.
It's debatable, but New York seems very strongly connected to the publication, the subject, the plaintiff. Arguing England has the most significant relationship seems tough here.
So the exception probably wouldn't rescue the claim. It likely fails under the general double actionability rule because the second limb wasn't met.
That seems the most likely outcome based on the source's framing. It highlights how the common law rules work for defamation, even with the exception. Mirrors Activity 8.3.
Shows the difference from Rome Tusset's approach.
Okay.
Hey, last big one. The sample exam question. Himalayan climbing accident. Post-2007, Mr. and Mrs. Adams, UK English. Claude and Marie, French students. Sherpas, Nepalese. Mr. Adams negligent, broke brakes. Claude dies. Mrs. Adams injured. Sherpa injured. Everyone sues Mr. Adams in England. Advise Marie for Claude, Mrs. Adams, and the Sherpa.
Okay, multi-claimant, single incident. Tort is negligence. Post-2007 means Rome Tedesic applies to all claims in England. We use Article 4 for each.
Let's take Marie first. For Claude, French, died in Nepal.
Yeah.
Suing Mr. Adams, English.
Apply Rome 2, Article 4. Start with 4. Where did damage occur? Claude's death occurred in Nepal. So 4.1 points to Nepalese law.
Script 2. Common habitual residence. Claude French and Mr. Adams English. No, 4.2 doesn't apply.
Check 4.3. Manifestly more closely connected elsewhere. Connections to France, England, but accident death in Nepal. Unlikely France or England are manifestly more connected than Nepal.
So for Claude's claim via Marie, Article 4.1 to Nepal, no 4.2, no 4.3. Result. Nepalese law likely applies. Any Nepalese-specific laws, like a passenger statute, would be relevant. Repeat. 4.1. Nepal, no common HR, no manifest connection, Nepalese law.
Correct. Now, Mrs. Adams English, suing Mr. Adams English, injured in Nepal.
Apply Rome 2, Article 4. Start with fourth thing. Where did damage occur? Injury in Nepal. So 4.1 points to Nepalese law. Unless.
Step 4.2. Common habitual residence, Mrs. Adams English, and Mr. Adams English. Yes, same habitual residence, England.
So Article 4.2 applies here.
It does, and it displaces 4.1. Because they share a common habitual residence in England, the applicable law for Mrs. Adams' claim against Mr. Adams is
English law. Repeat. English law applies under Article 4.2 due to common habitual residence.
Crucial outcome. It means those Nepalese rules mentioned in the facts, wife suing husband, punitive damages, they don't apply if English law governs via 4.2. English law decides those issues.
Big difference. Okay, finally, the Sherpa, Nepalese resident, injured in Nepal, suing Mr. Adams English.
Apply Rome 2, Article 4, start with 4. Where did damage occur? Injury in Nepal. So 441 points to Nepalese law. Unless.
Check 4.2. Common habitual residents, Sherpa Nepalese, and Mr. Adams English.
No.
4.2 doesn't comply.
Check 4.3. Manifestly more closely connected elsewhere. Sherpa is Nepalese, injured in Nepal, incident in Nepal. Connection to England via Mr. Adams isn't manifestly closer than Nepal itself.
So for the Sherpa's claim, Article 4.1, Nep is Nepal. No 4.3, no 4.3. Result, Nepalese law likely applies. Repeat. 4.1 Nepal, no common HR, no manifest connection Nepalese law.
Correct. And any Nepalese-specific rules, like that state compensation fund mentioned, would be governed by Nepalese law.
These examples really show Article 4 in action, especially the power of 4.1 place of damage versus the 4.2 common habitual residence exception.
And the need to apply the steps methodically.
Absolutely vital for exams. Okay, that detailed walkthrough was really helpful.
Good. So let's just pull it all together one last time.
We've journeyed from the old common law double actionability rule, Phillips v. Eyre, and its flexible most significant relationship exception, Boys v. Chaplin.
Through the 1995 Act, with its statutory events, occur injuries sustained rule and the substantially more appropriate displacement, keeping defamation privacy separate.
To the modern Rum 2 regulation, post-2007, not retrospective, universal application, no renvoi, using the place of damage rule, 4.1, the key common habitual residence exception, 4.2, and the manifestly more closely connected escape clause, while still excluding defamation privacy.
That's the whole story in essence. Remember those key terms, the tests, the exclusions. Can you explain the journey? Can you explain the different ways to displace the main rules? Can you explain why defamation is different?
If you can map that out, you're in really good shape.
It's definitely been a deep dive.
It really has. It shows how the law grapples with balancing certainty and fairness when things get messy across borders.
Yeah.
From rigid rules to more flexible, sometimes complex approaches.
And it makes you wonder, this evolution we've traced, focusing now often on place of damage, but with big exceptions, is it actually fairer or just more complicated? Does the complexity make it harder to predict the outcome?
That's a really good question. And what about the future? With things like cyber harms, online issues, where damage is everywhere and nowhere specific, how will these rules based on physical location cope?
Seems like the story of tort choice of law isn't finished yet.
Definitely not. Well, that does bring us to the end of this particular deep dive.
Thanks so much for tuning in. We really hope breaking down these rules and cases has helped clarify things for you.
And remember, the source material came courtesy of the University of London for educational use.
And this deep dive was brought to you by Sinorbit Academy, Sri Lanka.
To everyone listening, especially if exams are looming, truly, the very best of luck. You've got this.